Hello, everybody. Hello, Joey Bag of Donuts. Hello, Salty Buddha. Good to see you guys this morning. Yes, morning, not night shift. Yeah. I needed my people. That's all there is to it. I needed my chat. It's been one of those days. So I just wanted to be here with you guys, and we'll share in some beautiful court together. Yep, it's the day shift. And I'm so happy you can finally be here with me for it. Oh my gosh. Thank you, Joey. Thank you so much. You know that means everything to me. You are seriously so amazing. I don't even deserve to have friends like you guys. For real. I am, oops, I'm going to switch it back to this computer. I'm pulling it up right now. I didn't see all of it, but it certainly looked interesting from what I did see. So we're going to enjoy it together.
The victims in this case, they're his adoptive parents. Yeah. Were they his adoptive parents, correct? Or are they biological?
I didn't know the difference.
I don't know, but they're his parents. I know it because he kept saying these aren't my parents. This isn't my parents.
All right, we're going live here.
You already are. I love him.
Thanks for coming, Josh. No problem. Good morning, sir. Can you hear me?
Yeah.
Are you James Juday?
Yeah.
Would you rather stand or would you like to sit down?
I'm good.
All right, I'll leave you standing if you're all right with that. This is file number 24803FY. It's entitled People of the State of Michigan versus James Charles Juday. Mr. Juday is presently connected by a Zoom link from the jail. His lawyer, Rhonda Ives, is here with me at the courthouse, and Chief Assistant Prosecuting Attorney Joshua Robert is here. Mr. Juday, to recap, you got charged on May 15th with home invasion in the 3rd degree for a dwelling on Hiawatha Drive in Sherman Township. That's a felony punishable by up to 5 years imprisonment and a fine of up to $2,000. You also got charged with malicious destruction of personal property. You broke a window allegedly and spray painted some things on the house. That's a misdemeanor alleged to be over 200 but less than $1,000.
None of true. So why am I here?
All right, here's why you're here. The matter was set for a preliminary examination and a pre-exam conference. Your attorney, Rhonda Ives, was appointed to represent you, and you basically wouldn't talk to her.
There's nothing to say. I didn't do nothing.
All right, well, so we've referred the matter for a competency evaluation at the Center for Forensic Psychiatry. And we got a report from the Forensic Center on August 13th. It was date stamped August 16th. We're supposed to set a hearing in that matter within 5 days of the receipt of that report. Today's 4 days after we received it. So this is a hearing regarding your competency to proceed. You've been stuck in jail now for 97 days and the case has just been on hold.
It'd be nice to get a real lawyer too.
All right, well, we'll talk about that. Mr. Robert, on behalf of the state, are you willing to stipulate to the admissibility of the report?
Yes, Your Honor.
It is dated August 13th from Carissa Carlson, PhD, a consulting forensic examiner and licensed psychologist with the Center for Forensic Psychiatry. Ms. Ives, are you willing to stipulate to that report?
I would stipulate to it, but I object to the conclusion that's been made in the report based on the lack of review of an interview of the defendant.
All right.
You want me to plead guilty to something I didn't do? There's nothing to talk about.
Well, I don't necessarily want you to plead guilty. You're entitled to have a trial. And your lawyer is willing to represent you at a trial, but in order to do that, you have to talk to her. No one's trying to get you to plead guilty to anything. We're trying to just move forward with the case. And this,
I did talk to her.
all right, well, here's what the psychologist says. First of all, competency has to do with your state of mind right now, today, and the day of the trial. Criminal responsibility, sometimes referred to as insanity, has to do with your state of mind at the time of the offense. We're not concerned about that right now. We're just concerned about your state of mind now. I get the sense that you're an intelligent guy, but you've got some oppositional issues. The statute, the competency statute says, a defendant to a criminal charge shall be presumed to be competent to stand trial. He shall be determined incompetent to stand trial only if he is incapable, because of his mental condition, of understanding the nature and object of the proceedings against him, or assisting in his defense in a rational manner. The court shall determine the capacity of the defendant to assist in his defense by his ability to perform the task reasonably necessary for him to perform in the preparation of his defense. So the examiner didn't get very far with you. The video conference lasted about 5 minutes. Mr. Jude terminated the interview prior to being asked questions about his legal case and understanding of the proceedings. He demonstrated the ability to advocate for himself as evidenced by his understanding that he could terminate the interview. So here's the doctor's opinion, Mr. Jude. I was unable to thoroughly assess Mr. Jude's mental condition at the time of the present examination due to his declining to participate in the evaluation. Because of this, I was unable to directly ask him questions to assess his understanding of the nature and object of the proceedings against him, or to assess his ability to rationally assist in his defense. So they didn't get very far. Then she goes on to state, an opinion on competency is required regardless of the level of participation of Mr. Jude. The time of the evaluation is reported refusing all psychiatric medication.
I don't need medication.
All right, okay, that's, in my opinion, due to the limited, well, let me finish this last part, then I'll let you tell me what you want to tell me.
Go ahead and look.
Well, okay.
That's how I'm being treated in here.
All right. In my opinion, due to the limitation of not being able to directly evaluate Mr. Jude myself, and my understanding of the statute, one has to opine the presumption of competency. So their opinion is that you're competent. You're standing there with no shirt on. You're trying to show me how
show me
thin
what's
you are
going on.
because of,
How I'm being treated in here? Yeah,
all right.
exactly what I'm doing.
All right, so you showed me that because of how skinny you are?
No, how I'm being treated in here.
All right,
Poison,
well, how are
gas, all that shit, you know about it.
Does he though?
So that isn't exactly a rousing endorsement for the doctor to find that you're competent. Mr. O'Bear, you have any thing to say about this?
In my review of the statute, the only other possible thing that I can see is for Ms. Ives to request an independent evaluation as one of the outcomes of this hearing. But it says that because of the presumption that the Center of Forensic Psychiatry or other facility officially certified by the Department of Mental Health will properly perform their functions, good cause justifying an independent competency examination should only arise in exceptional cases. So I guess that's one possible option. I don't know if any evaluation by any other person would result in a different outcome based on his unwillingness to participate.
All right, Ms. Ives, what's your position?
Well, Your Honor, I have some serious concerns if they're not able to fully interview the defendant. I don't believe that an accurate determination can be made, and based on statements that he made to me prior to, that caused my request for the competency evaluation causes me some great concern. I'm also concerned the fact that there were reports from the jail that the jail was supposed to send, and they if I look on page 2, those records were supposed to be sent on August 8th promptly, and then as of the date of the report on August 13th, those records were not received. I'm not sure what is in those records, and I'm not sure, but I think that they would be very appropriate to review, as well as have a full evaluation with the defendant. I mean, if that means we have to do an independent evaluation, I guess I would ask the court to allow me to find the resources to do an independent evaluation, or refer them back to Miss Dr. Carlson so that she could try to re-interview the defendant, and hopefully he'll just cooperate with that interview so we can make steps and proceed forward.
Well,
What are the chances of that? I don't think that that's very likely. It's really hard to evaluate someone who won't cooperate at all. But I think if they refuse to cooperate, that in itself should be telling enough to complete the finding of your report.
Mr. Jude, what was scheduled was a preliminary examination and a pre-exam conference. This is a felony charge. One is a felony, one is a misdemeanor. You've got a $20,000 bond, and everything just gets stopped in a timeout when there's a competency hearing.
Yeah, any proof on anything? No.
So we weren't able to do the pre-exam conference, and we weren't able to do the preliminary examination. So I ordered this evaluation, and they did it, but it didn't go very well because you weren't very cooperative. So go ahead, sir. What do you want to tell me?
I've been telling you everything. There's nothing what do you want to know?
Well, do you want to go forward with your case? Do you want to have a trial? You have a right to have a trial where the prosecution has to prove the case beyond a reasonable doubt. We can't move forward in the posture we're in right now.
Well, yeah, I'm not trying to stay in here for no reason, man. I'm already in here for no reason over 90 days. Did you look at
97
me?
days.
You see how skinny I am and shit?
Yes.
Yeah, you know.
Let me ask this. If I were to release you today, where would you go?
I don't know, I'd figure it out.
Well, I'd rather figure it out first.
Well, I gotta be able to go get my shit.
Yeah, well, are you willing to talk with your attorney so she can proceed to prepare your case for trial?
I don't care, man. If it gets me out of here. You see me, I'm starving, man.
Well, I see it, all right.
Getting poisoned every day. Gas, yeah.
Say that again?
Getting poisoned and gassed every day too. I know you don't care, but
What's that from?
ask them.
Did he say he was poisoned with gas? Mr. Jude,
Yes.
is that what you said?
He said he is poison gassed every day. The jail staff says you're on a quasi hunger strike and that you refuse to eat.
I've been eating.
All right, well, do that.
Your Honor, I'm confused. Is he making a statement that, what does that mean, poisoned gas?
Well, you heard the same thing I did. He contends he's being poisoned by the jail staff with poison gas. And he said, ask them.
You gonna let me out today or what? You just said something about it.
No, I just asked what you would do if you had somewhere to go. No, I'm not inclined to let you out without cooperating with your attorney. I can't even get to the first stage of the proceedings. You've been in jail for 97 days. If I order an independent psychiatric evaluation, it's probably going to take another 90 days. I don't believe that you're being poisoned by poison gas at the jail. It doesn't matter what I believe if you believe it. So what would happen if I find you to be competent? I would set the matter for a pre-exam conference where your lawyer would come and meet with you and discuss what to do with the case. It could be reduced with some sort of a plea agreement, or you could have a trial. Nothing prohibits you from having a trial where you have to be proven guilty beyond a reasonable doubt. But we can't even get to that point. This business about your belief you're being poisoned is new to
Can you
this.
bond me out? I've already tried. They won't let me.
Well, your bond is $20,000 cash or surety.
Yeah. I've already tried.
Well, there were also allegations that you violated a personal protection order. That's why the bond is so high. You kept going back to a place you were ordered to stay away from.
Well, I gotta go back to where my stuff is.
Well, we'll get to that point. At this point, I'm inclined to grant defendant's motion for an independent psychiatric evaluation.
And you do what you gotta do.
All right, thank you, Mr. Jude.
I'm
What I'd like you to do is cooperate with the next doctor and see if we can move forward here.
I'll talk to the doctor. There's nothing to talk about, but.
All right, I asked you to cooperate. They would get.
I mean, come on.
All right, well, I've seen enough of that. So, all right, Mr. Jude, have extra French fries or something. I'll be seeing you at our next hearing.
I wish I was eating.
Oh my goodness. Yeah, don't let him out, Judge Middleton. He needs help. For sure.
Let me look at the order. See what it says.
Judge Middleton's responses are just precious. Doesn't matter what the situation. Like, well, I've seen enough.
He's on his own hunger strike, I think.
Well, that's what the jail staff says. He says he's eating. This order doesn't have anything in here. All right, I will do an addendum to this, saying that I grant, Josh, you were looking at the statute. What section
So
is?
it's Michigan Court Rule 6125 D, independent examination. On a showing of good cause by either party, the court may order an independent examination of the defendant relating to the issue of competence to stand trial.
I did it once when I was prosecutor. Although it was upside down, the forensic center found the defendant to be competent. I was prosecutor, I didn't think she was competent. So I got an independent evaluation from an excellent doctor, Dr. Charles Clark. And he found her to be, actually it was that's a long story, but it was a terrible homicide case. All
Story
right.
time.
The trick is you got to find somebody, an independent doctor, to do the evaluation. I don't know if MIDC has some assistance in that. And MIDC may need to pay for the evaluation. But I can't tell. He was doing pretty good until we got into poison gas. And as the jail indicated, he's on his own sort of hunger strike. He didn't look any skinnier than Iggy Pop, but I don't know what he looked like before. So I will do an order for independent evaluation.
Okay.
And in the meantime, the bond will remain where it is. All right, thank you.
Thank you.
That's a tough case here. I don't really want to just leave him there, but I don't want to just let him out either. He has nowhere to go.
Yeah.
All right, thank you both.
Thank you. Thanks.
He's been having a lot of really tough cases lately. Last night we were watching him, and every single one of them, he started out with, "This is a tough case. This is a tough case. This is another tough case." That's how it went the whole night. We court crawled with him. And then I just happened to see that this morning, and I was like, oh goodness, that gentleman needs help. But I'll tell you what, the man could not be in better hands than those of Judge Middleton. He's going to take care of him. He's going to make sure that he gets the services that he needs, one way or another. I have a lot of respect for that man as a judge and just as a human being. He's an excellent human. Let's see what else we can find, right? Okay, I can't see chat at the moment because I am on the other screen, but we are going to go searchity searching. Oh my, this one's been going on a minute, but I don't know what it is. We'll start here. We can always jump ship if it sucks.
Speak with the people that were on top of her unit.
Yes.
Okay, and what was their response?
And Judge,
Okay, sorry, I got to back it up a little bit apparently.
we are here today seeking a judgment for possession only, attorney's fees in the amount of $950, and court costs.
All right, give me 1 minute, counsel. Let me hear from Ms. Lewis, and then if we're gonna need our witnesses, then we'll go ahead and proceed forward.
Thank you, Judge.
Go ahead, Ms. Lewis.
Okay, so on the day that he's talking about, I came home, I was there maybe 15 minutes and I heard a knock at the door. I answered the door and it's SAPD. And they asked if I had heard any discharge of a firearm, anything, and I said no. And he asked if I owned any firearms, I said yes, and he asked if he can see? And I said, sure. So I went to the safe, I got the gun and I given it to him. He checked it and everything. He gave it back to me and he left me with a card with a case number. And that was basically it.
Okay, so explain the bullet holes, Miss Lewis, in your floor or your ceiling.
I wasn't there, so I don't know what happened. I'm not trying to fight to stay in the unit. I just needed 5 extra days from today so that I could leave. I'm still packing my stuff. I'm not trying to stay in the unit at all.
All right, so since you are not well, let me rephrase that. You are not wanting to stay there. Counsel, have y'all had time to confer?
Judge, we're not going to confer on this particular matter. If Ms. Lewis is able to turn in keys, we're happy to discuss some resolution or release of judgment. Once the attorney's fees and court costs are paid. But at this point, we do need possession of that unit back, as obviously this is a serious incident and the notice to vacate was dated June 19th. So we're well over 2 months at this point that she's maintained possession of the unit.
Mr. Miller, let me hear about from Masters Ranch.
Absolutely. Jocelyn, Jennifer, are you on? I think they're trying to figure out how to
Yeah, I
unmute.
think.
They figured out how to turn the camera off. Unmuting's another button.
Did she log off?
I couldn't tell you, Judge. I have you pulled up. Let me see.
I just saw her and now I don't see her anymore.
Well, Judge, while we're waiting for that, I'm happy here to share my screen.
Go ahead.
Judge, can you see my screen?
Yes, counsel.
Okay, so this is a copy of the notice to vacate that was delivered to Miss Lewis. As you can see, there are several occupants into the unit. So whether Miss Lewis knew what was going on or somebody else who's authorized under the lease contract to reside there knows what's going on, I couldn't tell you. This is the police report that was done on June 2nd, and I can zoom in here. Let me see if that'll, maybe that's too much.
Right there.
And feel free to read through. 01, to my knowledge, is going to be Miss Lewis.
Mom, Travis.
And it sounds like Masters Ranch has made it back on, Judge.
Okay, hold on.
And I can't even zoom in to read it
right.
or.
Go ahead, Masters Ranch.
Yes, sir.
Yes, Miss Masters Ranch. Go ahead and tell me a little bit about what happened. We're talking about Miss Wendy Lewis.
Oh, yes. So we had got a report in. Basically, there was a bullet that went through one of the units. And then we went to go inspect the unit and we saw the bullet came from 11204 Wendy Lewis's unit.
Okay. Is there anybody on top of Miss Lewis's unit?
Yes.
Okay. Did you speak with the people that were on top of her unit?
Yes.
Okay. And what was their response?
And Judge, I want to really quickly, I want to clarify. It was the top floor unit that had the bullet enter into his unit. So the bullet came from Miss Lewis's ceiling through the floor of her upstairs neighbor. And so the upstairs neighbor was the person who originally notified Master issue.
So Miss Lewis is at the bottom and it went up.
Yes.
Okay, I got you. Okay. Go ahead, Miss. Is there anything else, Masters Ranch?
No.
Okay. Miss Lewis, why did you deny consent of entry to your unit?
Because I didn't know what exactly was going on and I didn't feel safe, so I did not let him in.
Okay, so why did you feel safe? It was an officer.
Because I don't feel safe around officers.
Okay.
And I've had an incident in those apartments where my kid's father was killed in front of our building, so I wasn't gonna let him in.
All right, and so Miss.
So who do you call when someone's trying to break into your apartment Or, I don't know, when a stray bullet happens to come through your floor, who do you call?
So Lewis, were you there the entire day?
No, I wasn't.
Okay, and do you have kids there?
I do, but they were not home.
So nobody was home in the unit all day long.
No,
Okay, so this mysterious gun hole just came out of nowhere.
I mean, I don't know. There's shootings out there all the time and bullets flying everywhere. So it could have came from anywhere. They're
Not
saying that it came
necessarily.
from my
If it's coming from the
apartment.
bottom of a floor, it's not coming sideways.
Okay.
It's coming straight up.
Okay.
So that's why I'm trying to realize a bullet don't come
I'm
from the
not
bottom.
fighting it. I'm not fighting it.
Okay.
I accept what it is. I just asked if I can have the 5 days to get the rest of my stuff packed to leave. That's it.
All right. Yes, ma'am. All right. So judgment's going to be for possession only. $900 in attorney fees, and you've got your 5 days to move out.
Thank you.
You're welcome, ma'am. Have a good one.
They
Thank
just
you,
want
Judge.
rid of
May I
her.
be excused?
Yes, counsel, have a good one.
You do the same, Judge.
Thank you.
They just wanted rid of her. They didn't even want any money. They're just like, just get out, please. Like, I don't blame them. And lady, there's a thing called trajectory with bullets, right? You can tell where they come from. And truth be told, it really doesn't take a whole lot. All you need is a dowel about this long, insert it into the hole, and boom, you know exactly which way it went. Oh, golly. I just can't with some people.
Yes, ma'am. Let me get RCGA on this side and Mary Tucker and Joyce Bennett on this side. And then,
Peyton Rogers for the plaintiff, Your Honor.
all those are Sweet Mama, I think, or what? Oh, all right. Miss Rogers, go ahead and get us started. What is the monthly rent?
Monthly rent is $1,150.
Okay. What is the total amount that you're seeking in back rent?
Total amount of back rent due is $3,450. That is for June of 2024 through August of 2024.
Yes, ma'am. All right. And you're Miss Tucker, correct? Miss Tucker, first of all, do you agree that your monthly rent is $11.50 a month?
Yes.
Second of all, do you agree that June, July, and August have not been paid and or partial payments?
Yes.
Is there anything you can do or offer them to become current?
Well, I've tried. They're based, they're not based here.
Mhm.
And we have to go through, I have to pay it through like ACE or somewhere.
Okay.
And they don't accept partial payments. So when I try to get my balance appurred, they won't accept partial payments. You have to pay the whole balance or nothing at all. So that's why I haven't been able to come current or pay anything, because they won't accept anything unless you're paying the full amount.
In the full amount, you don't have.
I don't have the full amount.
Okay. Miss Rogers, are you willing to accept any partial payments, or are y'all asking for the full amount?
We're asking for the full amount, Your Honor.
All right. And so, Ms. Tucker, I can't force the parties to accept any partial payments, especially if it's part of your lease. So if there's no disagreement of what is owed and no agreement as far as a repayment plan, the only thing legally for me to do is grant the eviction, unless for some reason you can become current.
I don't know how long they're giving me to become current. My
Probably
mom.
within the 5 days.
Okay, well then if I can't come current in 5 days, I'll just petition it to.
Okay. All right. So judgment's going to be in favor of the plaintiff for $34.50. You do have 5 days to move out, 5 days to appeal it or work something out with.
Okay.
Okay. All right. Thank you, guys.
Thank you, Your Honor.
Thank you, Ms. Rogers. FKH SFR versus Megan and a Robert.
Peyton Rogers for the plaintiff, Your Honor.
Yes, ma'am. We got Mr. Robert coming up. You can come on this side, Mr. Robert, so I can see you better. Go ahead, Ms. Rogers.
Thank you, Your Honor. This is a non-payment of rent case pursuant to a written lease. Lease was signed on June the 1st, 2023. Monthly payment, $2,235. Rent is due from June of 2024 through August of 2024. Total amount of back rent due is $6,385. Notice to vacate was sent on June the 10th, 2024, both regular and certified mail. Your Honor, we're seeking possession, back rent, and cost of court.
Yes, ma'am. Mr. Justice, first of all, do you agree that your monthly rent is $2,235 a month, your base rent?
Well, up until June, was my understanding it was 1985. And which,
Yes, Your Honor, he's on a month-to-month now.
Okay, so, after your month expired, then it went up to 2235.
that's what I'm hearing, yes, ma'am.
Okay, and your lease expired in June.
Correct.
Okay, so Miss Rogers, June was calculated at 1985, is that correct?
I believe so. The only, I added August at the 2235. But the
I'm sorry.
petition was filed in July, so I assume that that was calculated based on, let's see.
So,
And I can double check and make sure it's,
July and August are calculated at 2235, is that correct?
yes, Your Honor. 2235.
Yes, counsel, you're right, you're good.
Okay, I'm sitting here like, I can redo my math. if you want
No,
me
no,
to.
you're good. Okay, so Mr. Justice, yes. June was at 1985, and then after your lease ended, you went to the month, which was July and August. That's when they charged you the 2235.
Okay.
Okay, so, first of all, let me rephrase this. Do you agree that your base rent used to be 1985 and now you're on a month to month?
I do.
Okay,
yes.
and then, Mr. Justice, second of all, do you agree that June, July, and August have not been paid?
I do.
Is there anything you can do or offer them to become current?
So I asked to be able to pay the full amount, which I was under the impression I was going to be able to until this past Friday.
Mhm.
I was working with the VA at the American GI Forum, in which they said that they were going to help me become current. And then I guess after I submitted all the paperwork, whatnot, I don't know if they had to confer with them. And then at that point, they were told that they were not allowed, that they were not going to accept full payment. So then I found out Friday that was no longer an option.
Okay, so FKH turned it down.
So correct, in which I was working with one young lady, Shavonda, I think, originally we were on the up and up. She understood what I was going through. I expressed to her that I'm self-employed, and so we had some situation there. And my only income was from the VA. So, I've been in the process since COVID of getting a increase. And so I knew that was coming. There was gonna be some back pay, and I knew the VA.
So right now, the VA is still willing to help you become current, or not at this point?
If that was an option, I believe that they would definitely, I could become current, let's just say that.
Okay. So, Ms. Rogers, are you aware of the VA trying to help Mr. Justice with any financial assistance, or is that something y'all are not interested in?
Your Honor, that's the first that I'm hearing about that. All I know that they have asked us this morning is to move forward with judgment.
All right. So right now, Mr. Justice, take out the VA. Okay, is there anything you can do to become current at this point?
Yeah, I believe I could do that.
By
Absolutely.
when? How much and by when? I need some numbers, because we're
Okay,
looking at
I mean,
almost $7,000.
yeah, no, it's fine. If you look before, I've been in this position once before, and I've paid $10,000 to keep current, so it's not a matter.
I have
it's
his
just-
ledger balance too, Your Honor, if he needs that.
Correct, and so I did ask for that Friday also. I never received it, but I will need that, please, if you don't mind.
Okay.
And then, but yes, I can become current.
By when? Give me a time frame.
In 3 days.
3 days to become current?
Is that?
Well, I'm asking for a number so that I can ask Ms. Rogers to see if maybe she's willing to either reset it or determine what y'all are gonna do after.
I mean,
court. But I need.
Because
to
his
be able to
ledger
give her
balance
something.
is, his ledger
Go.
balance is $8,033.60, and they'll want that in full.
Okay,
That's fine.
so Ms. Rogers, I don't know, you have his ledger in front of him. He says that he's made ample amounts of big payments and to become current, so it's not an issue with him coming up with that money. He said maybe 3-4 days
No,
tops,
let's just do 48 hours,
48 hours, he can become current.
but I'll have to mail the payment, so that's why I asked for 3 days, because I'll overnight it.
Your Honor, we'll do a 1-week reset, and then in the time being, if he does pay in full, we'll file a dismissal. If not, we'll move forward in a week.
Ma'am, I'd also like to request to remove Megan Garza from there. It's been a process I've tried to do in the past. It's been unsuccessful. I'm not really sure if I'm going about it the correct way.
Who is Megan Garza?
She was also put on the lease as a tenant, but has not been for well over never pretty much.
But did she sign the lease?
She did.
It's gonna be up to Ms. Rogers if they want to dismiss it or not. Is she an adult or is she a
She's
minor?
an adult. She's here present.
Okay. Ms. Rogers, I don't know what the issue is with Miss Megan Garza. I don't know.
Your
I
Honor,
guess-
we don't have anything yet from our client removing her from the lease or any kind of an amendment or anything like that. So I believe he would need to speak with First Key and have her removed from the lease if that's. I don't know
Alright.
anything about that,
Can
Your
you tell
Honor.
me the total? dear, so
What
that
is
I
the
can get a
total,
check?
Ms. Rogers, the complete total to make a zero balance?
$8,033.60.
Okay.
And then at that time, you can call,
Can I
first,
get that address?
yes, and well, swing around here to the right. Ms.
Okay.
Rogers will give you all of that in the chat, only because we're live on YouTube and I gotta go through
Perfect,
it. Okay?
understood.
Alright.
Your Honor, all of that information is in his lease agreement where he needs to mail payment and stuff too.
You have a copy
It
of
wouldn't
that?
be to us.
I'd be lying
It'd
if I
be in his
said
lease agreement.
available, but I can locate it.
Yes, make sure you
Okay.
locate it because you remember, she's just a representative,
Understood.
so she doesn't know
So,
where the
Can
apartment
I get
complex is.
her name and number also? in
Yes,
case I
we'll
run
get
into-
it from the petition, Ms. Rogers, and we'll give them y'all's, counsel's information.
And now, just to put it in perspective, that's only 4 months apparently that he was behind because his rent was $19.85 and then it got raised to $22.35, I believe they said, which is insane to me. Why anybody would willingly pay that much for rent? You couldn't save up enough to move out. I mean, oh my goodness, you'd have to be making a lot of money to afford that. That's more than double what I even get per month. That is insane. I can't imagine that.
Thank you, Your Honor. That's all I have today. May I be excused?
Yes, Ms. Rogers, have a good one.
Thank you, Your Honor.
Ms. Marissa, if you want to give them the information of the attorney on the petition.
Thank you.
Yes, sir, you're welcome. Marcus Fuentes on this side and Ms. House on this side. All right, Mr. Fuentes, go ahead and get it started. What is the monthly rent?
$16.95 a month.
What is the total amount that Ms. House owes you?
3 months, June, July, and August, $5,085.
And this is strictly rent, no late fees, no
No late
penalties,
fees, just the, just the
rent times
Yeah.
3.
times 3.
Okay. Ms. House, first of all, do you agree that your monthly rent, your base rent is $16.95 a month?
Yes, ma'am.
Second of all, do you agree that June, July, and August have not been paid?
Yes, ma'am.
Is there anything you can do or offer them to become current?
Well, I'm actually putting my stuff in storage and I'm leaving the property.
Okay, so you are gonna vacate.
Yes.
Okay, so at this point, judgment's going to be rendered in the amount of $50.85. You've got 5 days to move out or appeal it. Okay,
Okay,
thank you.
thank you.
Thank you, guys. Sagittarius 1604 versus a Piper and a Joshua.
Yes, present.
All right, and then, I'm sorry, y'all are on. Okay, if y'all can unmute yourselves, please. Awesome. All right, give me 1 minute and I'll let y'all respond, okay? So, go ahead, guys.
I'm representing Sagittarius 1604 LLC. My name is Felicia Jackson. I'm filing for an eviction for non-payment of rent for $1,089 per month for July and August, and possession, no subsidies, and court costs.
What is your total amount that you're seeking in back rent?
$2,178.
178. And that is for July and August. Is that correct?
Yes, ma'am, correct.
All right. Miss America and Mr. San Diego, do you agree that your monthly rent that you pay a month is 1,089 a month?
Yes, Your Honor.
Okay. Do you agree that July and August have not been paid?
Yes, Your Honor. My concern is that Felicia did present us with a notice of vacate on 7/11/2024. We were only 11 days late. June had been paid. We're both unemployed, but due to unemployment and funds that we already had in savings, we've managed to pay rent on a monthly basis, even though we had to pay late fees. So at the time that we presented this notice of vacate, we were 11 days late. No option to pay the July rent late, or even with a late fee included. So with that being said, we were also informed that we would not be eligible to renew our lease because we are currently unemployed, which we are seeking employment. And so at that moment, we thought, well, I guess we're going to have to leave. So we did not pay July, and we have not paid August. And now Sagittarius is offering to renew our lease, and if we were to pay July and August, which has been, to me, pretty unprofessional because we were told one thing and we were preparing to leave, and at the last minute, now we're being offered to stay. You know, had we been told in July, we could have continued to make July's payment and honor August as well. But now the amount has increased, so therefore we're not eligible to pay that full amount. But I also want to bring up the issues that we've had.
Okay, so I'm going to stop you right there as far as the issues. If there's anything to do with the house, what hasn't been fixed, what isn't being fixed, what's broken, there's nothing I can do about that. That is a separate type of case, which I'm not stating you don't have recourse, I'm not stating you don't have the right to sue or take it up any way you want, but it's just not in this court, all right, for whatever they did or did not do to fix something, okay? So right now, all we're talking about is rent. So I don't know what the communication has been between you two or lack of communication. I don't know. All I know is that we are here now in this court on the verge of an eviction. So, is there anything that you can do to become current? Is that even an option? Is that what you want? Where are we at right now? Because let me tell you, Miss America, right now, if we proceed forward, you're going to leave here with an eviction on your record, which is going to be on your credit, and it's going to be for the amount that you owe. The only time they're going to take that off your credit is if you pay them what you owe them. And then they will release it from your credit. Okay. So I don't know where we're at now, Miss Sagittarius. Is there an option for them to stay? Or are you seeking judgment at this point? Because I think that even they're confused of if they are going to stay or go.
Okay, their lease does expire at the end of this month, and they initially were offered a renewal if they were current. But since that has happened, they are 2 months behind. When we spoke last week in the office, I did tell them they would have an option to renew if they became current and paid to a zero balance. But to my knowledge, that's not happening today.
Okay, so Miss America, I don't know again if there is a lack of communication or language barrier or any barriers as far as communication goes. But the option to renew your lease has always been there, but it's contingent on you becoming current. So in other words, as long as you're current, they will always renew your lease. But the minute you're not current and you're so close to your lease ending, that's where they're pulling back and forth, because they're not going to renew you if obviously you can't keep up on your monthly payments. Okay. And that's just what they're assuming. I don't know financially what's going on or what's going on with the family or anything like that. So right now, Miss America, my question to you is, can you become current?
No, ma'am.
No. Okay. All right. So, Miss America, then the only thing I can legally for me to do is grant the judgment in the amount of 2178. You do have 5 days to move out, 5 days to appeal it, or work something out with them, okay?
I'm sorry, Miss, Your Honor, can you repeat that? We had a glitch with our phone.
Yes, sir. Yes, sir. So judgment's gonna be in the amount of 2178. You've got 5 days to move out, 5 days to appeal it, or call and work something out with them.
Okay. Yes, Your Honor.
Okay, but just remember, if nothing is worked out, the eviction stands and you have only the 5 days to move out starting tomorrow, okay?
Okay, I have a question.
Yes, ma'am.
If we leave the apartment and we come up with a payment plan to pay them off, will that eviction be removed?
Once it's paid in full. Once the 2178, that's all you owe them legally, is 2178 for your judgment. Once that 2178 is paid off, by law, they have to do a release of judgment, and the landlords usually are aware of what they got to do.
Okay.
Okay?
Yes, Your Honor, we're just taking note.
No, you're fine. 2178.
Okay.
All right. All right,
Thank
guys.
you.
Thank you very much. Y'all have a great day, okay?
You
Thank
too.
you, you as well.
All right. All right, let the 10:30. I will be right back. We will resume the 10:30 docket in about 2 minutes.
Uh-oh, Judge needed a potty break. All right, Judge. We're going to fast forward quick because this is quite interesting. I am just shocked at how expensive the rent is in Texas. And apparently Washington.
Can you unmute yourself, please?
Yes, can you see me? Can you hear me?
I can hear you now, but I can't see you.
Okay,
There you are.
I do have the camera on.
Yeah, you're good now. You're just off a little bit.
Okay, can you hear me better now?
Yes, a lot better.
Okay, good morning
have any
again. How are you?
I didn't have any speakers, but if you could just make your announcement, please.
Of course. Buenos días a todos. Soy Pamela y soy intérprete de la corte. Estoy aquí para asistirlos si necesitan ayuda con su caso en español. Por favor, alcen la mano o digan algo por medio de Zoom para saber que sí necesitan mi ayuda el día de hoy. Por favor.
No, ma'am, still no takers.
Okay, I can hang on for a few minutes, no worries.
Yes, please, until the judge arrives.
Of course, thank you.
Thank you.
That is really nice that they do that. They just randomly have an interpreter make an announcement. If you need an interpreter, hey, I'm here, basically.
All rise. Justice of the Peace Precinct Court is now in session. The Honorable Michelle Garcia presiding. Ladies and gentlemen, please raise your right hand to be sworn in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Put your hands down. Have a seat. Thank you.
Let them know that once the, yeah. All right. Good mid-morning, everyone. Again, my name is Judge Michelle Garcia. This mid-morning, we're going to be conducting our second eviction docket of the day. So if you are not here for an eviction case, after docket call, please make sure you speak with my clerk, make sure you're in the right area or to get the status of your case. What I'm going to do is I'm going to go through the entire docket. When I call your name, please stand up. Let me know who you are or who you're representing. By just standing up, I have no idea what that means. Let me know who you are or who you're representing. Landlords and or plaintiffs, if it is now the 20th of August, so you can ask for the full month of August. August does not need to be prorated. Please make sure that you only ask for rent, no late fees, penalty fees, anything like that. You cannot ask, or court costs, because that's going to be given automatically in your judgments. Tenants, if you're wanting me to see an email, paperwork, anything like that, while y'all are waiting to be called up, please sit there and get organized. I'm not going to sit here and allow you 30 minutes to go through an email when you've had this time to sit down and go through them. Okay, so utilize the time that you're waiting to be called up to be prepared and get prepared. Okay. All right. Also, if everybody could please double check, make sure your cell phone is on silent. And by that, I mean your alarms, your notifications, anything that bings, please turn it off. I don't mind that you're on the phone, but I do mind when your phone volume becomes a distraction to the court. Also, we're live on YouTube. We have got to be accessible to the public, especially if we offer the Zoom option. This is a JP court, a court of no record. So at the end of each docket and or day, the videos will be deleted. All right, we're going to go ahead and get started. First case up is going to be Ivy. Oh, I'm sorry. Miss Skinner?
Yes, Your Honor, I'm here.
Yes, ma'am. I heard you made an announcement and nobody needs a Spanish interpreter. Is that correct? All right. Miss Skinner, well then, you have a great early lunch and we will resume back here at 1:30. I'm not sure if you're going to be the interpreter at 1:30.
Thank you. I think it's going to be somebody else, but I appreciate it and you all have a good rest of your day as well.
Yes, ma'am. You as well. Have a good one.
Thank you. Bye-bye.
All right, let me get Ivy Apartments versus a Judy Peace and a Daniela Vargas.
Ivy, Your Honor, ready?
Okay, I will be with y'all shortly. Pecan Valley versus a Rudy Valreal.
Pecan Valley, Your Honor.
All right, Mr. Valreal. Okay, I'll be with you shortly. Spanish Oaks versus a Raymond Kelly.
Spanish Oaks, Your Honor, go ahead and dismiss this, please.
Yes, sir. Mr. Kelly, case is dismissed. You're free to go. Thank you, sir. Spanish Oaks versus Michael Martinez and Patricia Grissom.
Spanish Oaks, Your Honor.
Okay, I'll be with y'all shortly. SFR Investment Borrower versus a Brenda Manis. Anybody here for SFR Investments 5 Borrower 1 LLC? Case will be dismissed. Melissa Maloney versus a Catherine Hurricks and a Calesso Thomas.
This is Catherine Herrick is present, but my attorney is currently in federal court. I'm waiting on him to get out of here, to be released from federal court to come to the hearing.
Okay, do you know how long that's going to be?
No, we do not know. I am actually waiting on a response back from him currently right now. That's why it was reset, because I seek counsel.
All right, well, you counsel, first of all, we need a letter of representation and we need to hear from counsel what's going on, because as of right now, I have no proof that you're even being represented.
Oh, okay. All right. I'll let.
All right. So as soon as you get a hold of counsel, I'll put you at the end of the docket, but we are going to proceed forward.
Okay. Yes.
Okay. Thank you, ma'am. Eloisa Jurado and a Valentin Jurado versus a Leonard Wright and family. Okay, I'll be with y'all shortly. Linda Derricking versus a Gilbert Powers III and a Megan Mensing Powers.
This Derek is with me on.
Is there a Gilbert or a Megan? Gilbert or a Megan? All right, Counselor, you gonna take your default or you wanting to modify? Okay, your default is granted. Thank you, guys. Y'all have a good one. 130112 Oak Terrace versus a Denny Anderson.
Nationwide.
Denny Anderson. Your default is granted.
Thank you.
Yes, sir. 1604 Lofts versus Athea Twist.
Nationwide.
All right. And you're Miss Thea? Okay. All right. I'll be with you shortly. Avistar at the Crest versus Louisiana Cruz.
All right, guys. The calling of the calendar thing is always the most boring part. So let's court crawl over to another one.
Let me get to your case here. Oh, you're just on for review?
Yes, sir.
Okay. I'll set you out to September 17th at 11.
Okay, thank you, sir.
If you have it paid, there won't be a hearing.
Okay.
All right, thank you.
Thank you.
I'm gonna bring in Cassie Myers.
Okay. Ms. Myers, can you hear me?
Yes,
What are we doing in your matter today, Ms. Myers?
I'm just gonna have to plead no contest.
Say what?
I'm just gonna have to take a plea of no contest.
Have you talked to the county attorney?
No. tried to talk to an attorney I had, but I can't afford it, so
Do you want to visit with the county attorney?
yeah.
Got paper and pencil?
Yeah.
Mr. Becker.
Okay, you can just call me at 785-628-9405.
Okay. And your name?
Joshua Becker.
Okay.
Ms.
Thank you.
Myers, contact Mr. Becker. If you resolve this, there will not be another hearing. If not, you'll be back on September 17th at 11, okay?
Okay, thank you, sir.
All right, thank you. You're excused.
Thank you. Have a great day.
You too.
Thank you.
Mr. Willis, audio and video?
Yes, Your Honor. Do you see me?
No, I don't. I hear you.
I'm not sure.
Okay, it looks like we're just waiting for you to pay, correct?
Yes, Your Honor, I'm waiting on the mail.
How long do you need, Mr. Willis?
Just until I get my first check and then receive the mail with the information from the courts. So about a week or two.
Okay, so September 17th at 11?
Yes, Your Honor, that would be perfect.
Okay, if you have it taken care of, we won't have a hearing, okay?
Alrighty.
All right, that's all I need from you. Thank you.
Thank you, Your Honor.
I'll bring in Thomas Wagner.
Wait. Yeah.
Mr. Wagner,
Hello?
can you take your hat off, please?
Yes, sir. How you doing today?
Good. All right, what are we doing in your case, Mr. Wagner?
Okay, I had a speeding ticket. Okay, and I was hoping to take care of it by today, but I got laid off from my job. But I started a new job, but now I'm gone, 2 weeks without a paycheck, which I was going to use to pay the ticket.
Have you talked to the county attorney's office?
I did, but they said I had to talk to you because I'm trying to do that. What is it? That deferred program too?
Diversion?
The diversion program. Yes, sir.
Okay, well, I'm gonna set you down to October 1st.
Okay.
My guy, you got a lot going on. That was a lot. I mean, that was practically a run-on sentence of the mouth.
Hopefully that'll give you plenty of time to get with the county attorney's office and get everything.
Yeah, I just got
resolved.
laid off. I got a job right away, within a week, but it messed me up a few paychecks.
Okay, October 1st at 11 o'clock unless you have it taken care of.
Okay, I appreciate that, Your Honor.
You bet, you're excused.
All right, thank you, sir. Okay, that's good. October 1st.
Yep, October 1st.
Okay, thank you, sir.
You're welcome.
All right.
I'm gonna bring in Mia Randa Albright.
This is why I edit. These awkward pauses right here.
All right, Ms. Albright. Can you hear me?
Yes, sir.
Okay. What are we doing in this matter, Mr. Becker and Ms. Albright?
She just needs to contact us.
Have you not contacted the county attorney's office, Ms. Albright?
I was not aware that I was supposed to because the last time that I had court, you had told me, or I had informed you that I was getting ready to go take my test at the DMV. And you told me to just let you know what happened with that. And that's what I thought was going.
What happened with that?
Failed it. I was supposed to go in yesterday and retake it, but I had a family matter come up. I rescheduled it for a week from yesterday. So it's on the 24th at 3 o'clock now.
Okay, so this is what I'm going to direct you to do. After you retake your test, contact the county attorney's office. If you get a good license, they will tell you how to send that to them, and then they'll help you resolve this case.
Okay.
And you'll be back on September 17th at 11 o'clock unless that's resolved, okay?
Okay, thank you.
All right, thank you. You're excused.
Thank you.
Okay, I believe the last 5 are interpreters, so I'll bring in Magdaleno Benitez from First Appearance.
Okay. All right, there's Mr. Benitez.
Yes, sir.
Mr. Benitez is here on 24 TR 1854.
Buenos días, señor Benítez.
Hola, buenos días.
Estamos aquí en el caso 24 TR 1854.
Okay.
He's charged in count 1 with speeding 76 in a 60-mile-an-hour construction zone.
Cargo número 1, exceso de velocidad. Iba a 76 en una zona de 60.
Okay.
Count 2, driving without a valid license.
Cargo número 2, manejar sin una licencia válida.
Entiendo.
Okay, understand?
He has a right to an attorney, he has a right to a trial.
Tiene el derecho a un juicio y tiene el derecho a un abogado.
Al juicio lo haría él ahora mismo.
Would you be able to go ahead with the trial right now?
No.
No.
Ok. Si quiero tratar sin el abogado, ¿qué pasa?
If I want to try and move forward without an attorney, what would happen?
He can still have a trial. We'll set it.
Aún puede tener un juicio sin un abogado.
Ok, lo voy a hacer sin un abogado. Bueno, pronto.
Okay, I'm going to move forward without an attorney so it can be faster.
Okay, we'll set him for a trial to the court. And he will get notice when that trial will be held.
Okay, van a poner su caso para un juicio y le va a llegar una notificación con la fecha de su juicio.
Digamos, ¿el juicio se haría también así online o cómo sería el juicio? Esa es la pregunta que tengo.
Would the trial be held via Zoom or would it have to be in person?
Is he still at the address that he has on his citation?
¿Aún está localizado en la dirección que puso en su citación?
Sí.
Yes.
Okay. If there's going to be video played, he will have to be here in person. If there's not video, he can appear on a Zoom.
Si se tiene que ver algún video, entonces tiene que aparecer en persona. Si no se tiene que ver ningún tipo de video, puede aparecer vía Zoom.
Ok, bueno, no sé qué clase de video, no, no tengo nada de algún video que se pueda mostrar o nada, o no sé.
Okay, I don't know what type of video. I don't have any video that I need to show or would need to show.
Well, if the state has video from the highway patrol trooper or the officer that made the stop.
Puede ser que a lo mejor el oficial de la carretera tenga algún tipo de video donde fue cuando lo paró.
Ok. Entiendo. Bueno, sería en ese caso, pues tendría que hacer lo que ellos manden.
Okay, I understand. In that case, I would have to do what is said.
Okay. All right. He'll get a notice of when that trial will be held.
Okay, entonces le va a llegar una notificación para cuándo sería la fecha de su juicio.
¿Está bien? Eso sería todo por hoy.
Is that it for today?
Yep, that's it for today.
Es todo el día de hoy.
Gracias. Buen
Gracias,
día.
igualmente.
I'm gonna bring in Marlene Astorga Medina.
Buenos días, señora Medina.
Hola, buenos días.
All right, Miss Astorga Medina is here on 24 TR 1936.
Ok, estamos el día de hoy en el caso 24 TR 1936.
Sí, muy bien.
All right.
She's charged in count 1 with speeding 80 mile an hour in a 60 mile an hour construction zone.
Oh my.
Cargo número 1, exceso de velocidad, iba a 80 millas por hora en una zona de 60.
Sí.
Count 2, operate a motor vehicle without a valid license.
Cargo número 2, operar un vehículo de motor sin una licencia válida.
Sí.
And count 3, child passenger safety restraint.
Y cargo número 3, llevar a un menor de pasajero sin las restricciones adecuadas.
Sí.
This is going to be expensive.
She has a right to an attorney. She has a right to a trial.
Tiene el derecho a un abogado y tiene el derecho a un juicio.
Bueno, acepto mi culpabilidad en eso y es la primera vez que yo estoy en un caso así, entonces no sé qué decir. O sea,
Okay,
pero lo acepto.
I accept I'm guilty. It's the first time I'm in this situation. I don't know what what to proceed with, but I accept my guilt.
Does she have paper and pencil?
¿Tiene papel y pluma?
Ajá, sí.
Yes.
Mr. Becker, would you give him the county attorney's phone number?
785
Okay.
628
Okay.
9405.
Ok, señora Medina, le voy a dar el número del fiscal, del procurador. Puede llamarle a él para hablar con él.
Ok, sí está bien.
Número de teléfono 785.
785. Ajá.
628.
¿6 qué, perdón?
28.
628. Ajá.
94.
94.
05.
05. Ok. Entonces, le voy a marcar a él y ¿qué es lo que sigue? Perdón.
Okay, so would I need to call this number and what's next? I'm sorry.
If she calls that number, they'll try to resolve the case. And then if they don't get it resolved, she'll be back on September 17th at 2:00.
Si llama ese número, tratarán de resolver su caso, de llegar a una resolución con usted sobre su caso. En dado caso que no lleguen a esa resolución, su próxima audiencia será el 17 de septiembre a las 2 de la tarde.
Sí, está muy bien.
Okay, it's fine.
Okay, any questions?
¿Alguna pregunta?
Ahorita mismo me puedo comunicar con él terminando aquí con ustedes.
Could I call him as soon as I'm off via Zoom?
Mr. Becker?
You can call me whenever works for you.
Le puede llamar en el tiempo que funcione para usted.
Ok, perfecto. ¿Y puedo utilizar también un intérprete con él?
Okay, perfect. Could I use an interpreter with him as well?
How about she contacts me by email?
Okay, si es mejor que lo contacte por correo electrónico.
Ok, ajá. Sí, está bien. ¿Me lo puede proporcionar, por favor?
Okay, it's fine. Could I have the email, please?
Yes,
All
J.
right, wait. All right. We know where that's going. So so we're gonna skip on over to a new one.
It's Burton.
Let's get another one going.
Not guilty plea in this case.
Okay. Then for the record,
Hold up.
okay, wonderful. Just making sure we're on the same page here. Let me get to your file, sir.
Oh. There we go. All right, now I'm going to scooch back. There we go.
ASL in.
Oh, I love ASL.
Good morning, Judge.
Yes, Your Honor. Good morning.
Good morning.
Good morning. And I see I have an ASL interpreter. I'm going to go ahead and take that case out of order so we can get our interpreter underway. Ms. Schuman, Mr. Edgerton, you know who that is?
It is Joseph Drummond.
Let's get Mr. Drummond up here, please.
ASL is a love language. It is. Truly. I love watching
Good
it.
morning, Mr. Drummond.
Good morning, Your Honor.
And I saw you sign good morning, so I presume that you can see the interpreter. Is that correct?
Yes.
Okay, wonderful. Just making sure we're on the same page here. Let me get to your file, sir.
This isn't Judge Dad, but he'll do. I'm sure. Oh, that's beautiful.
There we go. Mr. Drummond, looks like I've got you on one case with one count, that being simple battery in violation of NRS 200.481. And this is in case number 24 CR 10487. Sir, you.
Yes. Mm-hmm.
And did you have a chance to speak to your attorney, Mr. Edgerton, this morning?
Yes.
Mr. Edgerton, what are we doing this morning?
Your Honor, Mr. Drummond wants to enter a not guilty plea in this case.
Okay. Then, for the record, Mr. Drummond, how do you plead?
Not guilty.
Okay, I'll accept the not guilty plea. Looks like bail was administratively set. Any cause to revisit that, Mr. Edgerton?
Yes, Your Honor. On behalf of Mr. Drummond, we would ask that he be released on his own recognizance. He's housed at the CARES campus and intends to defend himself in this case and will not miss court.
When you say
Oh, go ahead.
when you say defend himself, is he going to do that with the assistance of the legal defender that was appointed?
Yes, that was a poor phrasing on my part. Just
No worries.
his interests.
No worries. Okay.
It scared
Housed at
me.
CARES. Let me hear from the city.
Your Honor, we think bail should remain as is. He scored extremely high on the MPRA. He scored a 13. In this case, it's alleged that he was chest bumping, head butting, and then punched a Reno ambassador, victim Brian Mueller. He also has lengthy criminal history, including a misdemeanor arrest for failure to appear or obey court order as recent as April of this year. And then again on November 2023, he's got another domestic battery conviction from 2022, another failure to appear after bail from 2022, and then again in 2022, and then again misdemeanor arrest for failure to appear or obey court order from 2022. So Your Honor, just based on those alone, he has 23 pages of criminal history. I could keep going, but we have concerns he's not going to show up for court. He's a danger to the victim. If he is released, we're requesting he have no contact with victim Brian Mueller.
23 pages of history.
Well, I gotta say, I find that the city's met its burden by clear, convincing evidence based on the criminal history, based on the prior failures to comply with court process, and then I have some community safety concerns as well, supporting the imposition of cash bail. Probably $1,500 is tantamount to a no bail hold. Would you agree with that, Mr. Edgerton?
Under his circumstances, yes, Your Honor.
You got any other ideas that we can think of so that there's something securing compliance and good behavior before time of trial that gives them at least a shot at getting out?
Well, Your Honor, I appreciate that. The difficulty of more enhanced versions of supervision are that there is a cost for testing and other compliance matters. Mr. does have access to some funds through Social Security. So if the court would, if the city has met its burden for monetary bail, reducing that to $500 bondable gives him some chance of posting it and then placing him on basic supervision, where the marshals could be instructed to follow up with him regularly. He also does show a functioning email address, which would also overcome some of the auditory barriers.
My understanding is that most of the bond companies aren't doing 500 right now because the cut is a little too low. Here's what I'm going to do. I find that the city has met its burden, that cash bail is necessary. I am going to reduce it to $1,000. I will make it bondable, give him at least a chance to get out while still having some monetary security to secure good behavior. If he is able to post that bond and get out, I'm going to order the following conditions. First, you will report on release. You're going to come down to municipal court and check in with pretrial services. Number two, you're going to submit to basic supervision on the conditions that you obey all laws. You pick up any antisocial behavior and I'm going to revoke your bail. Number 2, you will consume no alcohol, no drugs. You test dirty, I'm going to revoke your bail. Do you understand those conditions, sir?
Yes.
3rd, you will have no contact with the alleged victim in this case. And
Okay.
finally, you will submit to marshal supervision, and I will ask the marshals to follow up with you on a slightly more regular than usual level for basic supervision. I think that's probably as good as I can balance it to not make your economic circumstance an impediment to getting you out while satisfying my own concerns about your ability to follow court direction and keeping the community safe. Anything further from the city on this matter?
No, Judge.
Okay. Mr. Edgerton, anything further?
No, Your Honor. Thank you.
Okay. That's going to be court's order, and we'll try to get this set for trial as quickly as we can.
Judge,
Yes.
his bench trial is set for September 19th
Okay.
at 1:00 in the afternoon. Mr. Carl Hyland is his legal defender.
Okay, perfect. Thank you. You're free to return.
Okay, thank you,
sir.
Your Honor. Thank you.
All right, Madam Interpreter, thank you so much. See you next time.
Okay, thank you, Your Honor.
Yeah.
All right. Let's pick it up with the Reds list. Give me a second to get that sheet up.
When the attorney said that he'd be defending himself, like I swear my heart kind of stopped for a moment in panic. I'm like, that's a terrible idea. Don't do that. Please tell him not to do that. Thankfully, it was just poor wording.
All right. Okay, so my stuff's in order. So it looks like I'm looking for Timothy Nation, please. Or Tim Nation. Sorry, I'm not sure if Tim is the full name.
I can't work this wheelchair.
Yes. Blue door.
1 second, Your Honor.
No problem.
I'm in a wheelchair, but I'm cuffed, so I can't make it work.
There we go. Good morning. Mr. Nation, can you hear me?
Yes, sir.
All right, and I can hear you. So we are up and running. Looks like, according to my notes, we're here for a change of plea hearing in 24 CR 08163. First question to you, Mr. Nation. Did you have a chance to talk to Mr. Edgerton this morning?
Yes, I don't know about a change of plea. I've never even spoke to anybody before. There was no plea entered.
That's okay. It's possible that a plea was entered on your behalf, given the date of the charge, but we'll figure that out together. Mr. Edgerton, what's going on this morning?
Your Honor, based on my conversation with Mr. Nation, he does intend to change his plea to no contest to the simple battery, and we expect that sentencing would have to happen later this week to comply with Marcy's law.
Gotcha. Mr. Nation, I've heard from your attorney. Is that how you intend to proceed today? Do a no contest plea? Understand you're going to be waiting a little bit for a victim impact statement?
I'm pretty much been here longer than I would have been if I was convicted. So I have a heart assessment that I'm going to miss if I don't get out. And that's the reason I'm doing this.
Okay.
If I miss it, then I get taken off the heart donor list. I'm dying and I can't risk being here any longer.
Sir, the difficulty that I have is a procedural one. I want to tell you that I'm profoundly sympathetic to your plight. I have dear friends with heart conditions, and I am very sympathetic. The difficulty is that the voters of Nevada amended the Nevada Constitution to guarantee a right to alleged victims of crimes to make a statement prior to the imposition of sentencing, and I have to follow that constitutional mandate.
No, I don't have a problem with that.
Yeah.
How long would that take?
Ms. Schuman, think we can get this on for tomorrow?
Can we do Thursday?
Get it on for tomorrow. I am awfully sympathetic to heart issues.
Okay, you got it.
Okay.
Make it happen.
Thank you. Okay, so here's what we're going to do. I'm going to get this set, assuming you enter a no contest plea, which is what I'm anticipating. We're going to get this set for hearing tomorrow so that we can notify the alleged victim and see if they want to make any sort of statement.
Yes, sir. Can I make a statement to the court, please?
Give me a second. First, I want to process your plea, and then I will listen to you, although I will remind you that right to remain silent is usually in your best interest.
Yeah, and it's not about the facts of the case itself. It's about something side pertaining to it.
So generally, when you're represented by counsel, I talk to your attorney for everything other than the very minimum stuff that I need from you. I'm going to handle the plea. I'm going to talk to your attorney real quick. Then maybe I'll hear from you. I need you to understand it's not because I'm not interested or don't care in what you have to say. It's because I'm making sure I'm protecting your rights as we go through this process.
I understand that.
So step one, you're charged with simple battery in violation of NRS 200.481. Do you understand the charge against you, sir?
Basically, yeah. I mean, I remember being arrested.
Okay. You understand you're charged with battery, correct?
That's what I was told.
And you understand what battery is that correct?
Yeah, I assume assault.
Okay. Well, assault and battery are slightly different. Battery means you actually made contact with the person that you were involved with. You understand that, sir?
Yes, sir.
Okay. How do you plead to the charge?
As far as the definition of it, yes.
Okay, that's fine. And how do you want to plead today, sir?
I guess he called it no contest.
Okay. And no contest is when you don't necessarily admit the truth of all the allegations against you. There might be more to the story than what shows up on my paperwork, but you do concede that the facts would support a conviction if the matter went to trial. Is that correct?
Which is fact. I mean, I was defending myself, but I still did what I did.
Okay. So it sounds like maybe a little more to the story, but the facts are there. So I find the plea is knowingly, voluntarily, and intelligently made, so I will accept it.
Correct.
We will set this matter out for sentencing tomorrow to make sure that the victim's Marcy's law rights are vindicated. Mr. Edgerton, I understand your client wants to chat with me real quick. Do you know what he wants to talk to me about?
I don't precisely, Your Honor. He has a number of concerns, none of which I think would be germane to resolving the plea as we've done today. They would more function in a sentencing argument.
Okay. Mr. Nation, so you're going to see a judge tomorrow. Based on your attorney's statements, it sounds like maybe that would be the better forum to address these concerns.
I don't think he kind of understands what I'm saying, but
I'll listen to you, sir. Go ahead and say what you want to say. I'm going to let you know that if I think you're veering a little far afield, I might cut you off and tell you to talk about it tomorrow.
I want to make sure that the misrepresentations so far since I've been incarcerated are not held, in record against me. 5 times, not counting today, I've been told to get ready for court, and I did so. They told me if I wasn't really willing to walk, which I cannot do, that they would tell the court I refused to show up, which causes me to look bad, shows an FTA. But that was never the case. All of those times I was ready for court, and all of those times the court officers refused to take me, saying that if I either didn't walk, that they would say that I refused. I just want the court to know that I never once refused, nor would I ever try to.
Okay. Well, just so you know, you haven't been rung up for any sort of FTA. There's no sort of contempt, nothing like that. Not really germane to what we're doing here today.
Right.
Maybe something that comes up tomorrow at sentencing. I think Mr. Edgerton's instincts were right here. Right. But any of that issues has nothing to do with what you and I just went through today. So
yeah, I just wanted
concerns, and they're not an issue for today's proceedings.
Yeah,
I have you sent back to housing, and then we'll see you back tomorrow, sir.
All right, thank you. I just wanted you to know.
I hear you, sir.
Wow. What a bunch of lineup we've had. Oh. I know who that is. All right, guys. I am going to have to go for a little bit. My daughter's got a doctor's appointment, and I've been trying to multitask and get stuff ready for that. So I am going to go so I can head out and take care of that. And hopefully I will see you guys tonight. I'm very blessed to already have something edited and ready to go, so I can, chauffeur my kid all over and still have something ready. Thank you guys so much for coming out. It's been a lot of fun. Be safe. Be well. Let's try this again. Be safe, be well, stay sweet, and much love.